In this third part of 3.2, we will talk about how the roles of legal, compliance, and counsel are crucial in managing regulatory challenges. Legal teams interpret regulations, oversee legal holds, and handle regulatory communications, while compliance officers lead investigations, coordinate screening and escalation processes, and ensure proper documentation. External counsel provides expertise in complex or cross-border cases, regulatory engagement, and enforcement defense. Effective collaboration between these roles is essential for conducting thorough and defensible investigations. Managing frozen assets in 2026 demands strict adherence to overlapping US, UK, EU, and unlegal regimes, each with specific obligations for asset blocking, reporting, and exemptions. Under U.S. law, the Office of Foreign Assets Control, OFAC, requires that all property and interests of specially designated nationals SDNs within U.S. jurisdiction be immediately blocked, prohibiting any transactions unless specifically licensed. Blocked assets must be reported to OFAC within 10 business days and annually thereafter. The 50% rule mandates that any entity owned 50% or more by SDNs is also treated as blocked, even if not named on the SDN list. Violations can result in significant civil and criminal penalties. In the UK, the Office of Financial Sanctions Implementation, OFSI, enforces asset freezes under the Sanctions and Anti-Money Laundering Act 2018 (SAMLA). All funds and economic resources of designated persons must be frozen, and making them available directly or indirectly is prohibited. Relevant firms must report matches or frozen assets to OFSI as soon as practicable. Importantly, crypto assets are explicitly included and subject to the same freezing and reporting requirements as traditional assets. EU sanctions, implemented through Council regulations, require all member states and EU-linked persons to freeze funds and economic resources of listed individuals and entities. Providing funds or resources to these parties directly or indirectly is strictly forbidden. Prompt reporting to national authorities is required when assets are frozen or a match is found. The EU also applies a broad control ownership test, capturing entities controlled by designated persons even if not directly listed. The UN Security Council imposes asset freeze obligations on all member states through binding resolutions. States must freeze, without delay, the assets of designated individuals and entities and prevent their use. Humanitarian exemptions are available, allowing access to frozen funds for basic expenses or humanitarian needs with Sanctions Committee approval. These obligations are implemented through each country's domestic laws. Effective sanctions compliance requires understanding and adhering to the specific asset, blocking, reporting, and special provisions each jurisdiction. Effective sanctions compliance requires prompt identification, immediate asset freezing, meticulous record-keeping, timely reporting, and ongoing monitoring across both traditional and digital assets. Organizations must screen all customers, transactions, and assets, including crypto, against OFAC, OFAC, and EU consolidated sanctions lists using robust KYC procedures and blockchain analytics. Upon identifying a sanctioned party or entity, including those 50% or more owned by blocked persons, assets such as bank accounts, real estate, investments, and crypto holdings must be immediately frozen. Detailed, time-stamped records of asset type, value, location, and ownership must be maintained and retained for at least 5 years. Authorities must be notified within required timeframes. OFAC within 10 business days. OFSI as soon as practicable, and EU authorities without delay. Ongoing monitoring, including continuous rescreening and blockchain analytics, is essential to detect changes in ownership, asset value, or attempts to circumvent freezes. Managing frozen assets comes with significant challenges. Maintaining asset value is a persistent issue, as real estate and investments may depreciate while cryptocurrencies remain highly volatile. Legal disputes such as ownership challenges, third-party claims, and litigation further complicate asset management. Humanitarian licensing adds another layer of complexity, requiring specific licenses and strict reporting to ensure compliance. Additionally, cross-border coordination presents difficulties due to divergent national rules and regulatory frameworks. For instance, post-2022, the UK reported £28.07 billion in frozen Russian assets, while the EU and US froze billions more, including luxury assets and crypto wallets. These efforts frequently required international cooperation and the use of advanced tracing technologies to ensure effective enforcement and compliance. Mismanagement of frozen assets poses significant legal risks. Unlicensed dealings, such as unauthorized use or transfers, constitute clear violations. Failure to report frozen assets timely or accurately can lead to enforcement actions. Circumventing freezes through structuring is prosecutable, while poor record-keeping weakens legal defenses and compliance efforts.